Good afternoon, good morning, good evening, good night, depending on what part of the country you're located at. This is Jasir Jamal from Texas 1031 Exchanges, located down south of the country, of course. So before I start this video, just know every single video I have made by far and that I am currently in the makes of making and that I will post in the future, all the content in there is meant for informational purposes only, and it's not meant for any legal advice whatsoever. Before acting on any of my information, of course, please consult with your tax attorney, your CPA, or your estate attorney with regards to it. So without further ado, let's get into the video. So let's say, you have a partner and you both are on an entity that owns a property that you guys are about to do a 1031 exchange with. And unfortunately, before you guys sell that property, your partner ended up passing away. And of course, it's very unfortunate that that happened and you are still about to do the 1031 exchange, but your partner is not there to sign on behalf of his ownership interest in the entity. What happens then? So let's go ahead and talk about it. So you have Tina LLC, which is the entity, and then of course your partner over here, his name is T and your name is J. T passes away. What happens then? So if T had a will prepared or estate documents prepared, then of course whoever is going to be the beneficiary in that is going to go ahead and sign on behalf of his ownership interests, and everything will be good to go from there. But let's say T did not have a will prepared. What happens then? In that case, that depends on what state this entity is from and what state you're buying the property in. As far as my knowledge goes, the last time I checked here in the state of Texas, if you do not have a will prepared, then your wife is probably going to be your wife or your significant other or your spouse is going to be the person who's just going to go ahead and take control of your assets, and in this case, the ownership interests you have in any entities, and they will be authorized to sign on behalf of that. And that's pretty much how it usually goes. But if there's a time where that doesn't work either, but there is a time where your partner T over here went ahead and transferred his ownership interest to you, and it's on an affidavit that was signed and notarized by T, of course, then you should be good to go. You can just turn that over to us and the exchange can happen and you'll be able to sign on behalf of the entity. But if not, if there was no will prepared, it depends on state law, and that state law is going to dictate who's going to be able to sign on behalf of the entity. And if there is a will prepared, simple. The beneficiary of that will sign on behalf of the entity, and the exchange can happen and it'll be good to go. That's it for me today, folks. Without further ado, I really hope you got some knowledge out of this little example over here. And if you have any more questions, feel free to reach out to me. And until then, see you next time.